The envelope was wedged between my screen door and the door frame. When I got home from work on a Tuesday evening in early September, I almost landskapet it. I was tired. I was carrying 2 bags of groceries, and my mind was already on dinner. But something about the color stopped me. It was that particular shade of official beige that nothing good ever comes in. I set the groceries down on the porch, opened the envelope, and read the letter twice, because I was sure the first time I'd misunderstood something. I had not misunderstood anything. The Sycamore Ridge Homeowners Association had issued me a formal violation notice. The violation was listed as unapproved exterior modification, decorative address numbers, non-compliant font style. My house number. The little brushed bronze numbers I'd screwed next to my front door 18 months ago when the old plastic ones finally cracked and fell off. The ones I'd bought at the hardware store for $11. The ones that, as far as I had ever known, matched every other set of house numbers on my street. The fine was $25 a day, retroactive to the date of a compliance inspection I had never been notified of, conducted 3 weeks prior. $25 a day, 3 weeks. That was already $525, and the letter made very clear that the fine would continue accruing until I replaced the numbers with an approved style. I stood on my own front porch holding that letter and felt something shift inside me. Not panic, not even anger, exactly. Something quieter and colder than anger. I looked at my house numbers. I looked at the letter. I looked at my house numbers again, and I thought, this is not going to go the way they think it's going to go. My name is Renee Calloway. I'm 44 years old, and I've been a paralegal for 19 years, currently working for a civil litigation firm in Raleigh, North Carolina. I mention my job not to brag, but because it matters to this story, it matters a lot, actually, though I didn't realize quite how much at first. I bought my house in Sycamore Ridge 6 years ago, when my divorce was finalized, and I needed a fresh start. It's a 3-bedroom craftsman-style home on a quiet cul-de-sac, the kind of neighborhood where kids ride bikes in the street and people wave from their driveways. I put a lot of myself into that house. New kitchen counters, a perennial garden in the backyard, a reading nook I built into the bay window of the 2nd bedroom. It wasn't just a house. It was the first thing that was completely, entirely mine, bought with my money, decorated by my choices, answerable to nobody's preferences but my own. Well, almost nobody's. Sycamore Ridge had an HOA, of course. I'd known that when I bought. The annual dues were reasonable, $480 a year, and when I'd read through the C&Rs before closing, nothing struck me as outrageous. Lawn maintenance standards, approved fence heights, no parking commercial vehicles overnight, standard stuff. I'd signed the acknowledgement form and filed it away and mostly forgotten about it. The way you do when an HOA is behaving like it's supposed to. That was before Meredith Cook became board president. Meredith had moved into Sycamore Ridge about 3 years ago. Into a corner lot house she proceeded to renovate top to bottom, and within 18 months she'd somehow parlayed her obsessive attention to neighborhood aesthetics into the HOA board presidency. She was 51, trim, always in activewear, with a kind of highlighted hair and sharp smile that photographed beautifully, and concealed absolutely nothing about who she actually was. She had been, before moving here, a regional manager for a home goods retail chain, and she approached the HOA presidency the way she'd probably approached regional management: metrics, enforcement, and no tolerance for deviation. People on my street had mixed feelings about Meredith. Some of the older residents liked that the neighborhood looked sharp. A few people genuinely seemed to enjoy her organized neighborhood events, but a growing number of us had started noticing that Meredith's enforcement activities weren't exactly random. Certain houses got violation notices. Others, notably the houses of people who attended HOA meetings regularly and vocally supported Meredith, seemed to sail through inspections without issue. I had never attended an HOA meeting. I'd never had a reason to. That was about to change. The morning after I got the violation notice, I sat at my kitchen table with my coffee and a legal pad and did what 19 years of paralegal work had trained me to do. I made a list of what I knew and what I needed to find out. What I knew, I'd received a notice for non-compliant house numbers. The fine was $25 per day. It had been accruing for 3 weeks without my knowledge. The total already owed, according to the notice, was $525. What I needed to find out, whether the secondars actually specified anything about address number style, whether the inspection that identified the violation had followed proper notice procedures, and whether other houses in the neighborhood were in compliance with whatever standard they were claiming mine violated. I pulled up the secandars on the HOA's website. It took me about 40 minutes to read through the whole document carefully, which I should have done before buying. But, as I said, nothing had been a problem for 5 years. The section on exterior modifications was detailed. Paint colors required board approval, fence materials and heights were specified. Roofing materials were listed. I scrolled and scrolled. Address numbers. I found the relevant passage on page 23 of 31. It read, "Residential address numerals shall be clearly visible from the street and of a size no smaller than 3 inches in height. Style and finish shall be consistent with the architectural character of the home." That was it. That was the entire rule. No approved font list. No approved finish list. No specific manufacturer or model number. Just consistent with the architectural character of the home. My house numbers were brushed bronze. My house had bronze door hardware, bronze light fixtures, and a bronze kickplate on the front door. I had, if anything, coordinated my house numbers more carefully than most people would bother to. I grabbed my phone and walked my cul-de-sac, photographing every set of house numbers I could see. 19 houses. I documented all of them. Brushed nickel, matte black, polished brass, painted wood. One house had house numbers made of what appeared to be reclaimed barn wood with a wood-burning tool. Another had oversized modern numerals and a sans serif font mounted on a slate background. Mine were the most understated on the street. And then I drove to the end of the cul-de-sac and looked at Meredith Cook's house. Meredith had oversized, backlit, modern floating numerals in a sleek brushed aluminum, about 5 inches tall, mounted against a custom cedar plank. Very expensive looking, very contemporary. Her house was a traditional colonial revival. I thought about consistent with the architectural character of the home for a long moment. Then I went back inside and called the HOA management company. Sycamore Ridge used a third-party management company called Pinnacle Property Services to handle day-to-day operations fielding calls, sending out notices, collecting dues. The woman I reached was named Tamara, and she was perfectly pleasant and completely useless. She confirmed that a compliance inspection had been conducted on August 14th, and that my property had been cited for the address number violation. I asked when notice of the inspection had been sent to residents. She said, inspections didn't require advance notice under the current CNDARs. I asked whether I could see the inspection report. She said I could submit a written request, and they'd respond within 30 business days. 30 business days. That's 6 weeks for anyone counting. I asked who had conducted the inspection. She said it was the HOA's contracted compliance inspector. I asked for the inspector's name and credentials. She said that information wasn't typically shared with homeowners, but she'd note my inquiry. I thanked her, hung up, and spent the rest of the evening drafting a formal written request for every document related to my violation: the inspection report, the inspector's qualifications and contract with the HOA, the complete list of properties cited during the August inspection, the board meeting minutes from the session where my violation was reviewed, and the specific provision of the CCAND, RRs under which my house numbers had been deemed non-compliant. I mailed it certified. Return receipt requested. I also emailed it. I kept copies of everything. I was not yet worried, but I was paying very close attention. 3 days later, before I'd heard anything back from Pinnacle, I got a second letter. This one informed me that my failure to respond to the initial violation notice within 72 hours had been noted, and that I was being assessed an additional administrative fee of $150 for non-response processing. On top of the $525 already accrued, I now apparently owed $675, and the daily fine was still running. I stared at that number. I stared at it for a long time. The original notice hadn't mentioned any 72-hour response requirement. I went back and read it again. No mention of it. I pulled the SS Candors back up and searched for 72 hours, and non-response, nothing. I'd been charged $150 for a deadline that didn't exist in any document I'd been given. I drove to the next HOA board meeting, which was that Thursday evening at the neighborhood clubhouse. I had never been to one before. I arrived early, found a seat, and waited. There were about 15 residents in the folding chairs, plus the 5-person board at the table up front. Meredith Cook sat at the center of the table in a cream blazer, her reading glasses on a chain around her neck, a neat stack of papers in front of her. She welcomed everyone warmly and moved through the agenda: landscaping updates, pool maintenance schedule, upcoming fall beautification event, with the practiced efficiency of someone who'd run a lot of meetings. Then she opened the floor to homeowner comments. I raised my hand. I stated my name and my address clearly, and held up the 2 letters. I walked through the situation. The violation notice for my house numbers. The $525 accrual I'd had no opportunity to address before receiving the notice. And the $150 non-response fee charged against a deadline that appeared nowhere in the Candors, or in my original notice. I kept my voice level. I've sat in enough depositions to know that the person who stays calm usually wins. Meredith listened with an expression of patient concern, the kind a school principal wears when a parent comes in about a grade dispute. When I finished, she said, "Mrs. Hyand Calloway, the secondiers are very clear about exterior modification standards, and the board takes compliance seriously in order to protect everyone's property values." Connaissez, how is? I said I understood that, and I'd read the Candors carefully, and I'd like to know specifically which provision my house numbers violated, because as written, the rule required numbers consistent with the home's architectural character, and my brushed bronze numbers matched my bronze hardware throughout. She smiled. The board made a determination on that. I asked when the board had made that determination, and whether it was in the meeting minutes, and whether I could see those minutes. She said the minutes would be available through Pinnacle Property Services in the normal course. I asked about the non-response fee and the 72-hour deadline. She said the board had authority to set administrative procedures, and those were communicated through the management company. I said I hadn't been communicated any such deadline in my original notice, and I'd like to see the written policy establishing it. The smile stayed on her face, but something behind her eyes went very still. She said she'd take my concerns under advisement, and that Pinnacle would be in touch. I sat back down. A woman 2 rows behind me, mid-50s. Short gray hair caught my eye and gave me the smallest nod I've ever seen. I filed that away. On my way out, the woman caught up with me in the parking lot. Her name was Patricia Odom, and she'd lived in Sycamore Ridge for 11 years. She said, quietly, she does this. She picks somebody, and she just goes at them until they pay or they leave. Last year, it was the Hendersons on Birch Court. You're going to want to document everything. I told her I already was. Good, she said, because nobody else has ever pushed back. The next 4 weeks were a study in escalation. The fines kept accruing $25 every single day. I received a 3rd letter informing me that the total balance had crossed $1,000, and that under the HOA's governing documents, balances over $1,000 were eligible for lien filing on the property. The letter included a specific reference to North Carolina General Statute 47th, which governs planned community HOAs, and stated that the HOA had the authority to place a lien on my home. Then, I got a letter from an attorney. Not just any attorney, a collections, an HOA enforcement firm out of Charlotte called Whitfield and Associates, which apparently handled lien filings and collections for a number of HOAs in the region. The letter informed me that if my balance was not paid in full within 30 days, they would initiate lien proceedings against my property. A lien on my home. Over house numbers that cost $11. I need to pause here and tell you what a lien means in practical terms, because a lot of people don't know until it happens to them. A lien is a legal claim against your property that must be satisfied before you can sell or refinance. It attaches to the title. A homeowners association with a recorded lien can, under certain conditions and after certain procedures, actually move to foreclose on that lien. It's rare, but it's legal, and just the presence of a lien on your title creates problems if you ever try to sell. I sat with that attorney's letter for one evening and let myself feel the full weight of it. My ex-husband and I had divided our marital assets at the end of a very long, very expensive divorce. My home was my primary financial asset. The thought of a lien on it, let alone anything beyond that, made me feel sick in a way I hadn't felt in years. Then I picked up the phone and called my boss. I work for a firm called Brennan & Cho. My supervising attorney is a man named David Brennan, 58 years old, 30 years in civil litigation, and the kind of lawyer who gets genuinely interested in a good legal problem, the way some people get interested in a puzzle. I'd worked with David long enough that he trusted my read on things, and I trusted his. I laid out the entire situation. The violation notice, the accruing fines, the non-existent 72-hour deadline, the attorney's letter, everything. I also told him what I'd found walking the neighborhood, the inconsistent enforcement, the complete lack of specificity in the SEAC Condra's address number provision, and Meredith Cook's own backlit aluminum numbers on her traditional colonial house. David was quiet for a moment. Then he said, "The non-response fee is the most interesting part. If they charged you against a deadline that doesn't exist in writing, that's potentially unfair and deceptive trade practices territory under the North Carolina statute. And if enforcement is selective, if they're citing some homeowners and not others for the same condition, that's an equal protection argument in a private HOA context, which is trickier, but not impossible." He said he'd need to think about whether Brennan & Cho could formally represent me. There were conflict check considerations, but that he'd help me informally and point me to someone if needed. Then he said something that I wrote down. "In the meantime, get the inspection records for every property in that neighborhood for the last 2 years. If the pattern is what you think it is, that's your case right there." I already had the certified letter request out to Pinnacle, but Pinnacle's 30-business-day clock was ticking slowly. I needed another way in. That's when I remembered North Carolina General Statute 47F3 to 118. Under the Planned Community Act, homeowners in North Carolina have the right to inspect HOA financial records and meeting minutes. It's not unlimited. The HOA can protect certain attorney-client privileged material, but board meeting minutes, financial statements, and certain operational records are accessible to members. I submitted a formal inspection request directly to the HOA, citing the statute, and requested the minutes from every board meeting in the past 24 months. All violation notices issued during that period, and all compliance inspection reports. They had 10 business days to respond. Meredith Cook, I was about to discover, had been keeping very detailed records. She just hadn't anticipated that I'd ever see them. I thought I was making progress. I thought the formal records request would shake something loose and we'd find our footing. Then, I came home on a Wednesday evening to find a notice taped to my door, not mailed, taped informing me that my balance had crossed $1,500, and that the HOA had retained Whitfield and Associates to file a lien on my property. The filing, the notice said, would occur within 5 business days. 5 business days. I called David from my driveway, still sitting in my car. He listened and said, "Okay, we need to slow this down. I'm going to refer you to someone tonight." The someone was a woman named Carol Tate, who ran a small firm in Durham that focused specifically on HOA law and homeowner disputes. She had 17 years of experience, a direct manner, and when I explained the situation to her the following morning, she didn't seem surprised by any of it. "The lien threat is real, but the timeline is aggressive," she said. "They're trying to pressure you into paying before you can mount a defense. The question is whether their underlying violation claim is valid enough to support a lien, and based on what you're describing, I'm not sure it is." Carol filed an emergency motion, to stay the lien pending a hearing. She argued that the violation notice lacked the specificity required to establish a valid basis for the fine. The CONDers contained no objective standard against which my house numbers could be measured and found non-compliant, and that the additional fees had been imposed without proper written disclosure. The stay was granted. The clock stopped. The lien didn't get filed. But Meredith Cook's response to losing the lien momentum was to call an emergency special meeting of the HOA board. I was notified by email at 9:47 in the morning. The meeting was scheduled for 7 p.m. that same evening. Under the CNDers, emergency meetings required only 24 hours notice technically. The email satisfied that requirement. But practically speaking, most working homeowners couldn't rearrange their evening on 10 hours notice. I left work early. I called Patricia Odom, who spread the word to the half-dozen other residents she'd been quietly networking with since our parking lot conversation. And I called Carol Tate, who said she couldn't appear at an HOA meeting as my attorney, but that I could certainly bring documentation and speak on my own behalf. I walked into that clubhouse at 6:55 with a 3-inch binder. There were more residents at this meeting than I'd seen at the regular one. Patricia had done her work, and word had gotten around that something was happening with the Calloway situation. I counted 22 residents in the chairs. Meredith looked around at the turnout with an expression I couldn't quite read. The board voted, in open session, to formalize what they were calling the Address Numeral Compliance Standard, a new document that retroactively defined acceptable house number styles for Sycamore Ridge. It listed approved finishes, approved font styles, and, notably, specified that backlit or internally illuminated numerals required a separate Architectural Review Board approval. That last provision was aimed directly at one set of house numbers I could name. But the retroactive application was the piece that mattered most to me. They were creating a written standard after the fact, and attempting to apply it to violations that had already been issued under the previous, vague standard. In my years of legal work, I'd seen courts look dimly on exactly this kind of thing. I raised my hand during comment period and made that point plainly. I said that the violations issued against me had been issued under the existing SANDAR language, that I'd been fined against a standard that hadn't been written down, and that creating a new written standard after the fact, and attempting to ratify prior enforcement with it, raised serious legal questions. Meredith said the board had authority to issue clarifying guidelines. I asked whether the clarifying guidelines would apply equally to all homeowners, including board members. Silence. I said I'd walked the neighborhood. I had photographs. I listed 7 properties. I named the addresses that appeared non-compliant with the new standard as written. I noted that at least one of them was a board member's residence. Meredith said all homeowners would be subject to the standard going forward, and that the board would conduct a neighborhood-wide inspection. 2 things happened in the next 10 days that changed everything. The first was the records I'd requested under the statute arriving from Pinnacle. The documents were extensive, over 300 pages, and I spent a weekend going through them with a yellow highlighter, and the same focus I use when I'm reviewing discovery for a case. What I found was, in a word, remarkable. In the 24 months covered by the records, the HOA had issued 114 violation notices. I went through every one. I cross-referenced them with addresses, and where I could, with what I knew about the residents at those addresses. The pattern that emerged was not subtle. Of the 114 violations, 67 had been issued to a cluster of about 20 properties. Those same 20 properties had been inspected an average of 4 times each in 24 months. The remaining properties in the neighborhood, roughly 50 homes, had been inspected an average of less than once in that same period. I looked at what those 20 properties had in common. Some were rentals. Some were owned by people who'd spoken up at HOA meetings. Some were owned by people who'd submitted complaints about board decisions through the management company. A few I couldn't identify any obvious pattern for. None of them, as far as I could tell, were owned by people who attended HOA social events, volunteered for HOA committees, or had any visible relationship with Meredith Cook. The financial records told another story. The HOA had collected $62,000 in fines and fees over 24 months. Of that, $28,000 had gone to Whitfield and Associates, the collections firm, a nearly 45% cut on every dollar collected. I called Carol Tate and read her those numbers over the phone. She was quiet for a moment and then said, "Get me copies of everything." The second thing that happened came from an unexpected direction entirely. Patricia Odom called me on a Sunday afternoon, and I could tell from the first second she spoke that she had something. "Do you know who Whitfield and Associates is?" she asked. I said I knew they were the law firm the HOA used for collections. "Did you know," she said, "that Greg Whitfield's wife is Meredith Cook's sister?" I put down the coffee cup in my hand very carefully. Patricia had discovered this through what she described as a lot of Facebook and some county property records. Greg Whitfield, the principal of Whitfield and Associates, had married a woman named Susan Cook in 2019, Meredith Cook's younger sister. The relationship wasn't disclosed anywhere in the HOA's financial records or meeting minutes. The HOA was directing 45% of its collected fines to a firm run by its president's brother-in-law, and nobody had disclosed the relationship. In North Carolina, HOA board members owe fiduciary duties to the homeowners they represent. Directing association business to a family member, without disclosure and without demonstrating that the arrangement was fair and competitive, is a textbook breach of fiduciary duty. I called Carol first thing Monday morning. "We're filing a counterclaim," she said. The hearing was set for a Thursday morning in Wake County District Court. The HOA's case, presented by Whitfield and Associates, which was not remotely awkward given what we now knew was straightforward. I had non-compliant house numbers. The HOA had the authority to fine me for violations, and I owed the accrued balance, which by this point had grown to over $2,000 with fees. Carol's defense was three-pronged. First, the violation was not valid because the C&R provision didn't establish an objective standard against which my numbers could be measured and found non-compliant. Consistent with the architectural character of the home is a subjective determination, and when you apply it to my brushed bronze numbers on a Craftsman, home with bronze hardware throughout, there was no reasonable basis for finding a violation. We showed the photographs of my numbers. We showed photographs of neighboring properties, including board member properties, that were not cited despite equal or greater deviation from any consistent neighborhood standard. Second, the fees beyond the daily fine, the non-response fee, the administrative processing charges were invalid because they had no written basis in the C&Rs and had not been properly disclosed. Under North Carolina's Planned Community Act, assessments against homeowners must have a basis in the governing documents. Third, and most significantly, the counterclaim for breach of fiduciary duty. Carol laid out the relationship between Greg Whitfield and Meredith Cook, the volume of HOA funds directed to his firm, the lack of disclosure, and the absence of any competitive bidding or fairness determination in the record. Meredith Cook sat at the plaintiff's table in a gray blazer and did not look at me once during the entire proceeding. Greg Whitfield was not present. His firm had sent an associate, which I noticed the judge also noticed. The judge's ruling came 3 weeks later in a written order. The violation was found to be invalid. The seconder provision as written did not provide sufficient objective criteria to support a compliance determination, and the board had not followed its own procedures, including adequate notice in issuing the original citation. All fines and fees associated with the violation were vacated. The HOA was ordered to pay my attorney's fees under the statute's fee-shifting provision. On the counterclaim, the judge found that the undisclosed business relationship between the HOA president and the collections firm constituted a prima facie breach of fiduciary duty, and that the matter was referred to the North Carolina Secretary of State's office for further review of the association's financial practices. $2,000 in fines gone. Attorney's fees covered. And the matter wasn't over. The HOA's board held a special meeting 4 days after the ruling. I wasn't there for it, but Patricia was, and she called me afterward. The meeting had turned contentious almost immediately. Several homeowners, including some who'd never spoken up before, came in with printouts of the judge's ruling and demanded answers about the Whitfield relationship. Meredith's prepared statement, which she apparently read from a printed page, described the ruling as a misunderstanding and said the board Renee Ned committed to maintaining community standards. One of the other board members, a man named Roy Tillman, who'd been relatively quiet throughout everything, interrupted her mid-sentence. He said, on the record, that he hadn't known about the Whitfield connection, and that he believed the board had a responsibility to address it directly. He moved that the board retain independent legal counsel to review the HOA's finances and the collections firm contract. Meredith called the motion out of order. Roy said he didn't think it was out of order, and asked the board secretary to record his motion regardless. 2 other board members voted with Roy. The motion passed 3-2. Meredith Cook resigned as HOA president 10 days later. Her resignation letter, which was circulated to the full neighborhood per HOA bylaws, cited personal reasons and the increasing demands of the presidency. It thanked the community for the opportunity to serve. It did not mention house numbers. The independent review that Roy Tillman's motion set in motion took about 2 months, and found what I'd already suspected from the financial records. The collections firm had been significantly overpaid relative to market rates, and there was no documentation that the HOA had ever sought competitive bids before retaining Whitfield and Associates. The review also found that Meredith had signed the engagement letter with the firm personally, in her capacity as board president, without bringing it to a full board vote. The HOA's new board, Roy Tillman, became interim president, and the remaining positions were filled at a special election with some new faces, including Patricia Odom voted to terminate the Whitfield, an associate's contract, and issue a refund assessment to homeowners to partially offset the overcharges. It wasn't a massive amount per household, about $200 each, but the principle of it mattered. The Secretary of State referral resulted in the HOA being placed on a monitoring list and required to file enhanced financial disclosures for the next 3 years. Meredith Cook, as far as I know, faced no criminal charges. What she did was likely a civil breach, rather than outright theft, but she is no longer in any position of authority in this neighborhood, or, to my knowledge, anywhere else. Greg Whitfield's firm still operates. I can't speak to what, if anything, came of the ethics inquiry that Carol filed separately with the state bar, based on the undisclosed conflict of interest. Some things move slowly. My house numbers are still there. The same brushed bronze ones I bought at the hardware store for $11 18 months before any of this started. I pass them every single day when I come home, and every single time I see them, I feel something that I can only describe as a combination of pride and bone-deep exhaustion. I won. But I want to be honest with you about what winning cost. Several $100s in attorney's fees beyond what was recovered. Months of stress that followed me to work and kept me up at night, and an enormous amount of time and energy that I'll never get back. The final fees recovery helped. But there is no award that gives you back the evenings you spent reading HOA documents, instead of doing literally anything else with your life. What I want you to take from this isn't just the satisfaction of watching Meredith Cook walk out of a boardroom. It's something more practical than that. If I hadn't worked in legal for 19 years, I might have just paid the fine. A lot of people do. A lot of people get that first notice and think it's easier to write a check than to fight. And they're not wrong. Fighting is hard and expensive and exhausting. But Meredith Cook was counting on that. She was counting on me to calculate that the cost of resistance was higher than the cost of submission. She ran that calculation on every homeowner she targeted, and for 4 years it worked. The thing that made the difference for me wasn't that I was a paralegal. Exactly. It was that I read the documents. I read the secondors. I read the statutes. I made the records requests I was entitled to make, and I documented everything I did. Any homeowner can do those things. They take time, but they don't require a law degree. They just require the willingness to treat your own property rights as something worth defending. Your HOA is not above the law. It is subject to the law specifically, to the state statutes that govern planned communities, which exist in every state and which give homeowners specific enforceable rights. If your HOA fines you, they need written authority to do it. If they charge you fees, those fees need a documented basis. If they enforce rules selectively, that pattern can be documented and used. If they direct your money to companies run by their relatives, without disclosing the relationship, that is a legal problem for them, not just an ethical one. Read your candors. Submit requests in writing. Keep copies of everything. Find out who your state's HOA, regulatory authority is. And if things escalate, find an attorney who specializes in HOA law, not a general practitioner. Someone who knows the specific statutes in your state. I never wanted to spend a year of my life fighting about house numbers. Nobody does. But my home is the most important financial asset I have, and it belongs to me, and no board president in a cream blazer, with an undisclosed family arrangement, and a padded collections contract gets to tell me otherwise. Not without a fight. If you've ever had an HOA come after you for something that felt completely unreasonable, I'd love to hear about it in the comments. You're not alone, not by a long shot. And if this story felt familiar, if you recognize something in the way these fines escalated, or the way the rules seem to bend for some people, and not others, let me know. Every one of those stories deserves to be told. If you want to see more, give this video a like, and subscribe to HOA Stories Uncovered. Turn on your notifications so you don't miss the next one.